In Chapter 1, we establish something critical. Modernization reduces ambiguity and increases enforceability. We saw how clearer rules make discipline more predictable. Now we begin applying that understanding to one of the most practical changes in the 2025 Overhaul, the creation and clarification of the inactive license status. If Chapter 1 explained the legal framework, Chapter 2 explains how your actual license is affected. Because before you advertise, negotiate, draft a contract, or earn compensation, one foundational question must be answered. Are you legally authorized to perform licensed activity? That question now has a clearer answer than ever before. Created under ARS. Paragraph 32, 2130. The inactive license status was formally implemented under the authority of ARS, paragraph 32, 2130, which governs continuing education and renewal requirements. The legislature authorized flexibility in renewal structures, and the department adopted administrative rules to operationalize that flexibility. This is important. The inactive status was not created casually. It was authorized by statute and implemented by rule. That means it carries the full weight of Title 32 and is enforceable under ARS, paragraph 32, 2153, which we discussed in Module 1.3. So what does that mean in real terms? It means inactive is not just a casual description. It is a legally defined status with specific privileges and specific prohibitions. Understanding that distinction protects you. Allows renewal without continuing education. Let's start with one of the most attractive aspects of the new inactive status. Under traditional renewal rules, active licensees must complete continuing education, CE, before renewing. Failure to complete CE can create renewal delays or complications. Under the new inactive status, a licensee may renew without completing CE because they are not practicing. At first glance, this seems simple. If you are not selling real estate, you do not need CE. But here is where Chapter 1's lesson about clarity comes back into play. Inactive status gives flexibility, not freedom. You may renew without CE. You may maintain your license on record. You may preserve your ability to reactivate later. But you may not perform licensed activity. That is the dividing line. Avoids retaking pre-license education or the exam. Before this modernization, agents who let their license lapse beyond certain periods risked facing significant hurdles to reinstatement. In some cases, extended inactivity could require re-education or retesting. The new inactive status provides a structured path to maintain licensure without returning to square one. Think about the practical scenarios where this matters. An agent takes maternity leave for a year. A broker temporarily relocates out of state. An agent shifts careers temporarily but wants to maintain credentials. Inactive status allows those individuals to preserve their license without starting over. That is a meaningful benefit, but benefits always come with boundaries. Cannot perform licensed activity. Here is the most important sentence in this module. An inactive licensee cannot perform any activity that requires an active real estate license. That includes negotiating contracts, listing property, showing homes, collecting compensation, advertising real estate services. The prohibition is not symbolic. It is absolute. Let's make this practical. Scenario 1. You place your license on inactive status to avoid completing CE. A former client calls and asks if you can help them draft a contract just this once. You agree, thinking it is harmless. That is unlicensed activity. Even though you technically hold a license, you are not authorized to act. That becomes a violation of statute and rule and can trigger discipline under ARS, paragraph 32, 2153. Scenario 2. You are inactive but allow your name to remain on a team website. Leads come in. You forward them to another agent and accept a referral split. That is licensed activity and compensation participation. Inactive status does not create a loophole. Remember Module 1.4. Less ambiguity equals easier discipline. The department does not need to debate whether you were sort of practicing. The question becomes factual. Were you active at the time of the conduct? If not, enforcement becomes straightforward. How this connects to supervision inactive status also affects brokers. Under Article 11 supervision standards, a designated broker must ensure that only active licensees perform licensed activities. If a broker allows an inactive agent to operate under the brokerage, supervision liability attaches. That overlap is not accidental. Licensure, Article 3, and supervision, Article 11, are structurally connected. Inactive status clarifies expectations for both the individual agent and the designated broker. A court perspective on licensed activity. Arizona courts have long held that engaging in activities requiring a license without proper authority can invalidate compensation claims. In cases involving unlicensed activity, courts have denied commission recovery even when services were performed. Now apply that principle to inactive status. If you are inactive and perform licensed services, not only do you risk administrative discipline, you risk losing enforceability of compensation claims. Inactive status is not a soft retirement, it is a legal boundary. Why this reflects the 2025 risk shift. This is a perfect example of the shift we discussed at the end of Chapter 1. Previously, there may have been confusion about renewal timing, grace periods, and eligibility categories. Now the categories are clearer. Active, inactive, eligible. Each has defined consequences. That clarity protects organized agents and exposes careless ones. And because the status is explicitly codified in rule, enforcement becomes easier. How this leads into Section 2.2. In the next module, we will examine renewal mechanics and status changes under R4 28303, including administrative severance and modification processing. Understanding inactive status first is essential, because renewal timing and status selection determine whether you are legally authorized to act. Licensure is not just paperwork, it is permission, and permission in real estate is statutory.